Any mention?
May I please, Your Lordship?
Yes, Mr. Hassan.
Item 42, my lord.
What do you want to item 42?
My lord,
Upgrading?
my lord?
Upgrading?
My lord, it's for hearing, my lord. I seek 2 weeks' time, my lord.
No objection.
Okay.
Highly obliged.
Lordship, I beg to make a mention for an unlisted motion today, Lordship.
What's the matter about?
Lordship, here, Lordship, what has happened, Lordship?
Demolition?
No, Lordship. Risk purchase notice has been issued against me, Lordship.
Risk purchase?
Risk purchase, Lordship. Here, Lordship, what has happened? I am a company, Lordship, dealing in the business of selling ferrosilicon, Lordship.
Ferrous alloy?
Ferrosilicon, Lordship. Now, subsequently, Lordship, during the subsistence of the like the contract, Lordship, my furnace, Lordship, there was an explosion in my company, Lordship, for which I could not fulfill. Therefore, Lordship, I had invoked the force majeure clause, Lordship, which was not appreciated by the respondent sale, Lordship, and now they issued the risk purchase notice, Lordship. So, having no alternative.
What is the liability risk purchase?
Lordship, amounting.
Amount?
Crore. Lordship, it's not mentioned the exact amount, Lordship.
What is the value of your contract, ferrosilicon? What is the value of your contract?
Lordship.
What is the value of supply order? You think you're supplying ferrosilicon,
Lordship,
right, to
Lordship,
PSU
Lordship.
something, sale?
Yes, Lordship.
Yes.
48 crore, Lordship. 42.
In fact, my lord, with your permission, my lord, this matter is covered by a lordship's order
Yes.
passed earlier in similar matter, my lord. This was upheld, my lord, by the division bench.
Regarding the same thing?
Same thing, my lord, risk purchase only. And when there is an alternate remedy, my lord, neither of the parties, my lord.
Okay.
Pioneer carbide, Lordship.
File it. It's filed or not filed?
Lordship, we are in the process, Lordship.
May I please, Your Lordship? Your Lordship,
Yes.
Lordship, I would like to mention item number 27, Your Lordship.
My please, Your Lordship, I am appearing on behalf of
Yeah, objection.
No.
Yes, you want to adjourn it? You want to upgrade it?
Yeah, adjourn it. Item 27.
Since you've come all the way from Tura, I thought you want to upgrade and do
28 I'll be doing, sir. Item 28.
Yes?
Yes, Your Lordship.
22 matter, huh? Okay, after 2 weeks, yes. Yes.
Deeply obliged.
Please, Your Lordship. I beg to mention item number 31, Your Lordship.
31.
Yes, Your Lordship. The learned DSGI is out of station, Your Lordship.
31, Jaichand Kumar Gope.
Yes, Your Lordship.
Yes, okay. Who's for the... Where's Mr. Jha? You inform him?
Yes, Your Lordship.
Yes.
Highly obliged, Your Lordship. Your Lordship, a similar prayer for item number 24 and 25.
Yes. 24 and?
25.
No objection?
No.
24, 25?
Yes, ma'am.
Yes, okay.
Highly obliged, Your Lordship.
Hello.
Yes.
Item 37 is connected to
One of those teacher matters. They're like terminal illnesses.
Lordship, I
37 per week.
Lordship, I beg to mention item number 26 of the main list, Lordship. 26. Lordship,
Abdul Jalil.
Lordship.
Who's the other side?
Lordship, I'm praying if this matter can come up after 2 weeks, Lordship.
Yeah, objection.
Lordship, similar prayer for item number 29, Lordship. Lordship, it's a joint request, Lordship.
Yes?
It's a joint request, Lordship.
No objection, Lordship. Item
Yeah,
29.
objection. No.
No, Your Lordship.
Where's the Paul? In town.
Lordship, he is here, Lordship. Some personal difficulty, Lordship, today.
Is that a PAF matter?
Wow.
Yes, yes, work matter.
Yes.
Acknowledge.
Please, Lordship.
Lordship, I beg to mention item 39 on behalf of AG Moment.
Behalf of
Or A Moment.
who's 39?
39, Lordship.
No objections, Your Lordship.
Similar prayer for 40 and 41, Lordship.
Where's you have 40 year there also?
Yes, Your Lordship.
Okay, yes. Oh, this all they're all connected.
No, Lordship. 40 and 41 are connected. Notice.
Okay, yes.
Duly obliged.
Much obliged.
My Lord, I beg to mention item number 32. I'm respondent number 5 and 6. My Lord,
32.
for 2 weeks. Yes.
Who's the other side? AG Movement.
I'm for the petitioner, Your Lordship. No objection, Your Lordship.
Why not objecting? Not doing these matters? Why? 32. Yes. Yes.
Highly obliged, Your Lordship.
Very sad.
Lordship, I beg to mention item number 33 and 34. Connected matter. Conducting counsel out of
I
station.
think don't need to make a hearing list. Yes. And so,
No objection, Lordship.
naturally, you have no objection.
Obliged.
Much obliged.
May it please Your Lordship. Lordship, I beg to make a mention of item number 43. My Lord, I pray if the matter can come after 2 weeks, my Lord.
No objections,
Except
Your
for
Lordship.
Mr. Paske's matter, there's no other matters, all gone. 25 is adjourned, right? Yes.
Duly obliged.
Item number 1.
We'll take
It's
it.
a
Na?
transfer matter, my lord.
But is the council invested with the power?
Yes, my lord, they have the power.
302.
That is what the instruction is, my lord. So, my lord, only thing is this private respondent is there. Let notice go, my lord, and then we can argue this matter.
What
There
stage
we-
is it?
My lord?
What stage is the case?
Charge has been framed, my lord.
It's only stage of charges, it's not a stage of hearing.
No, my lord. Charge has been framed, my lord.
Yes, Mr. Guru.
My Lord, we'll take it with those pending matters, my Lord.
See, the
Notice has to
matter,
go first,
if it hadn't gone to Supreme Court, would have clarified everything. But
Still,
then,
it's still pending, my Lord.
But on the meantime, I'll take steps on the private respondent, my lord. Private respondent number 2.
304. 34 IPC is heard Mr. SD. I should notice Mr. R. Guru Lalit, PP. State of Meghalaya is present, except was behalf of number 1. Notice to issue fund number 2. In the meanwhile, this after 3 weeks.
Deployed.
We're not staying proceedings. We're still in a state of considered charges.
Item number 2.
Yes, Mrs. M.
Please, Your Lordship. After proper instructions, Your Lordship, it is found that this is the second round of litigation for the same matter, Lordship. But on a comparison of the first and the second matter, Your Lordship, the thing is that, granted, there are certain similarities since it is the same case, but the prayer
You have
portion
not
is
mentioned it
different.
in your petition that your second
No,
time.
Your Lordship, we had no
Why?
instructions of the same, Your
For that,
Lordship.
your petition has to pay cost.
Yes, Your
How
Lordship.
much are you going to pay?
Lordship, that
1
was
lakh.
no, Your Lordship. That was an oversight on our part as well, Your Lordship. We were
See,
on bad
sometimes as a young
instructions.
lawyer, you have to be, sometimes you can't believe what clients tell you straight away.
Yes,
you
Your
have to use
Lordship.
your own intuition in your mind also.
Yes, Your Lordship.
And you have to come clean because sooner or later it'll come out. It's not a question of, it's not a question of like, they think they're very smart as a press and other side will find out like this. It's already there on record.
Yes, Your Lordship. I
When
appreciate
when
that.
they looked at the matters, it's already they'd withdrawn limited file afresh, no doubt, but it
Yes,
should be
Your
mentioned in the writ petition.
No, Your Lordship.
That we had filed, we take liberty to file afresh, and this writ petition has been filed on a different set of circumstances where additional prayer has been made.
Yes, Your
for,
Lordship.
For sending the matter to reference, whatever.
Yes, Your
Correct.
Lordship. Yes, Your Lordship. That was
So how much cost did he pay for that?
Your Lordship. If
Fix the price, how much did he pay?
I apologize on regarding that, Your Lordship. This was
As a counsel, how much cost do you think he should pay?
I am not able to decide on that matter, Your Lordship.
So you're protecting your client, yes.
No,
Yes,
Your Lordship.
Mr. Karun.
Lordship, primarily Lordship, the petitioner does not have any locus to file his petition, Lordship. And also, Lordship, if you look at the prayer in Miss application 58 and prayer in the writ petition number 33 of Lordship,
This case?
68 or 58 of 2020.
It is the connected miss case to this instant case, Your Lordship.
And prayer made out in writ petition 33, Lordship, there are some similarities.
That we've seen, because this matter I had examined it, because in the earlier petition they pleaded for keeping in abeyance the dispersal of compensation.
Yes, Your Lordship.
That's the only thing. Here they've asked for, in the main petition they asked for
The reference.
Let me take down third Mr. LCM issued notice. The page Karan Lang is present, accept notice on behalf of
Lordship, respondents number
1 to
4, Lordship.
124, yes. No notice to the private respondents at this stage.
Lordship, the private respondents will be required to be issued.
Notice. Because you want to have preliminary objection on locus, correct?
Yes, Lordship.
So you want to take that on your own, or you want these people to come and be harassed?
Lordship, they would be. Lordship, I just received a document, also a settlement agreement between the private parties, Lordship, and the petitioner.
You're aware of that?
It depends, Your Lordship, on what agreement that has been received.
Which has been registered before the.
Between the private respondents and.
Before
this is different, Your Lordship. This is a.
No, I'm not privy to that. So anyway.
Yes, registered before the DC.
Yes, petitioner take step for issue notice to the private respondents within 3 days. Stop. The instant matter. It's the second round of litigation by the same petitioner before this court. Stop. However, though the earlier petition named WPC number 33 of 2025 was withdrawn on 6/3/2025 with liberty to take recourse to alternate remedy and also liberty to file afresh. You so advise of slide by this court, comma, no mention has been made of the earlier case in the incident petition. Stop. Then Ms. LCM Letter Counsel petition has submitted that this fact was not made known to the counsel at a time filing incident petition, and that but however, the prayer in the incident petition is not identical to the prayer made in the earlier petition. He prays that the matter be taken up for consideration. Stop. Next one, Mr. H. Karun Lang, Learned Counsel for the Learned GA, has raised preliminary objections with regard to the locus of the petitioner to prefer the incident petition. Stop. He has further submitted that with regard to the land in question,
yes,
an agreement has already been signed and registered by the private respondent. That's what's number?
Number 5.
This Emma Taren.
Yes, Your Lordship.
And also the respondents in title suit number 7 or 20.
We're not going to go there. Has already sent by the respondent number 5 as regards the compensation that is to be paid. He therefore submits that there being no cause of action, the petition should not be entertained. Stop. Next paragraph. Having heard the counsel for the parties, as observed earlier, though this is a second round litigation which should have been revealed in the petition, in this fresh petition. Stop. this court, so you don't want to pay cost.
Your Lordship, if your Lordship may be so gracious as to overlook the oversight.
This court is of a mind to inflict some cost on the petitioner, but on the prayer of the council, the same is condoned for this time. Stop. This is the matter after 2 weeks.
2 weeks.
To allow Mr. H. to bring a written objection on record. Yes.
Highly obliged.
Otherwise, it'll become anyway. We can do what one judge has been doing in this. I think is Telangana High Court or something. So instead of giving cost, he'll ask the petitioner to come, go and buy 1,000 saplings, and go and plant at some area that's been deforested.
That sounds like
under supervision for the government. So himself he goes and plants. So I think that'll work better.
That sounds like a better workout, Lordship.
So he's ready to plant trees?
I think he would be.
Item number 3.
Obliged, Lordship.
Yes.
Your Lordship, this matter is about the retirement benefits of my deceased son, Your Lordship.
Retirement benefits of?
Of my deceased son. I was working as LDA, Your Lordship, in the office of MTC, and I expired in
MTC.
MTC. Yes.
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 I'm for the one.
Right, Mr. Malangyang, in the consultation issue notice. MS Esbert Shaji is present behalf of
Respondent number 1.
1 and Mr. M.U. Ahmed, Vice Mr. S. Sen on behalf of number 2. Just after 10 days of instruction, please.
Much obliged.
Item number 4.
Please, Lordship. Lordship, this is regarding the Nokma matter whereby the EM and the CAM they are challenging this present repetition. The EM has allowed the private respondent to register as the Nokma of that particular account, the EM.
Then after registration of whom?
The private respondent. Because that petitioner here, we are alleging that private respondent is not from the bloodline of the original Nokma, and they allege that she is adopted. But we are saying that we don't have any knowledge and we have concern with regard to the adoption. And to that effect, there is no framing of issues, nothing that taking of evidence that was not there. Even they said that she has been adopted by the late mother. Earlier, we have filed a petition, it was submitted, but however, the petitioner has withdrawn herself from the Nokma. We have filed an application to the CM and CM he has given, but yes, to be now again she is coming and reclaiming. Earlier we have withdrawn because she has withdrawn herself.
No, she was claiming she was in the office of Nokma.
Now she again her
husband.
Yes. She don't have the husband. Only she has the husband, but we don't know. But the petitioner, private respondent, she is the only because mother and
she is the only female heir.
Yes,
private respondent.
Private respondent. Earlier, mother was there, but mother expired.
What grievance will you have if she is the only female heir?
No. They are saying that she was adopted. That is an allegation of adoption because we said that she was not adopted for becoming the Nokma, and we as per the Garu customary law, Nokma and
who's this number 2?
Number yes, number two is the Tra means they die.
And now this
and then the number 3
is
and they are all the uncles and uncle of those private respondent, and number 1 is
the uncle of private respondent. They say that she's not adopted.
They are saying, we are saying that.
But how can they be charged and they say they should not adopted if they say they're the uncle of this private respondent? If they're not, she's not adopted, then they're not uncles. If they belong to your or your.
It is a settled law, my lord. This petition is not maintainable itself.
No.
It is a settled law, my lord, where the mother and the father, they are the authority who has to decide who will be the next Nokma. And it is a settled law, my lord.
No, he's submitting that after as per synopsis I've seen just now, they filed a petition and the private respondent withdrew from the post Nokmaship. And now,
but his synopsis speaks, my lord, that just when the Nokma was decided, my lord, the decision of the Chara was not taken.
Right.
Chara's decision is mandatory or not, my lord, that is a settled law, my lord.
Yes.
Where in the absence of mother only, Chara comes to play a role, my lord. But when the mother is still alive,
because she cannot nominate any
now
daughter.
mother is already expired, Lordship. Mother also is expired. So our allegation, the petitioner allegation is because we without the concern of trust and without the concern of the Chambugong Mahari, the EM has allowed.
Where's the order? Let's see.
This Lordship.
Are we disposed of now only? Where is it? Where's the order that you've impugned?
That impugn order is EM order is page 30, my lord.
Because we can't reopen, dispute that already dead.
No, the dispute means like earlier was already when this petition was there. There is earlier repetition.
So when she withdrew, who was occupying the office of Nokma at that time? If you say she withdrew from she resigned, she withdrew. Who was occupying the post of Nokma at that time?
Nobody was occupying the Nokma. And now only her application for withdrawal was still yet to be accepted. I have mentioned in the petition also.
Let's see, it's 19 order. Read it. Page 30.
Page 30. Since the petition of Remy Marak apply for Nokmasip registration of Rongkon Songatagri Akeng, pursue also the record submitted by the Majundar Mujadar number 4 have gone through the report related to Akeng record and found correct. On pursuing the report, the Mahari people are summoned to appear in my court on 30/08/2019 for registration of successor Nokma of Akeng, said Akeng. The petitioner Sri Remy Sesmarak present Nokma Midila along with close Mahari people of the last recorded Nokma present today before me. I have personally examined the statement of Marvin Sesmarak Sra and earlier recorded their statement in the separate seat.
Then
now,
see, this order does no objection at the point of time.
Yes.
All the Maharis went before
Yes.
the EM and said that register responsible number 4 as Nokma.
Your Lordship,
She's the daughter of last recorded Nokma, this Remy C.H. Marak.
Your
Right?
Lordship, this petitioner, they are also the important trust in Mahari. Their
cannot be summoned in the
record is not, their statement has not been recorded.
Where is the meeting you had? Where's the meeting you had with all the Chas and Chachis and Maharis? Where? That you said let's file a case in court to it. Where is it? You have brought anything on record to show that it's a general consensus?
No, Your
Let's see.
Lordship.
Then appeal against the appeal order. What happened in the appeal?
The appeal was, they have appealed the order of the,
Yes. Now let's see the appeal order. Where is it?
this is the appeal order, Lordship.
Yes. Appeal order where?
Page 47, my lord.
Okay.
Page 47. The appellant prepare an appeal, Garus Council so against the judgment and order dated 30/08/2019 of the executive member Island and Revenue Garus Council in revenue case 51 AC of 2019. By this judgment and order, EM has declared the respondent to the successor Nokma of Rongkon Songatagri Akeng. The counsel for the appellant submitted that the EM in the EM by its judgment and order dated 30/08/2019 had appointed the respondent number 2 as Nokma of Rongkon Songatagri Akeng case based on the application of the respondent number 1, but the none of the clan member including the present appellant have been consulted prior to the appointment of respondent number 2 as Nokma of Rongkon Songatagri Akeng. The counsel for the appellant further submitted that prior to application for registration of respondent number 2 as Nokma of respondent number Rongkon Songatagri, the Akeng there was no Mahari meeting convened by the appellant and none of the clan members, especially the Chra, uncle, brother of Nokma family have been informed of her decision to register respondent number 2 as Nokma of Rongkon Songatagri. The Akeng land being the property of the clan member, only respondent number 1 on her own could not have legally applied for registration of respondent number 2 as Nokma without the consent of clan members. the counsel for the appellant submitted that the Srimati Rimi Seth Marak, the present Nokma, has no female issue, and at the time of adoption, respondent number 2, two clan people, especially the elder male members of the Nokma family, were not consulted, and there is no meeting in this regard. In absence of Dibra adoption ceremony to represent respondent number 2, therefore appointment of respondent number 2 as Nokma of Rongkon Songkotalgri cannot be accepted, and pray for cancellation of the appointment of the respondent number 2 as the Nokma of Rongkon Songkotalgri Akeng. On the other hand, counsel for the respondent number submitted that the clan members, including sons, respondent number 2 Rimi Sismarak, have been consulted, and they have consented to appointment of respondent number 2 as the Nokma of Rongkon Songkotalgri Akeng. It is also submitted by the counsel for the respondent that the last registered Nokma, that is the respondent number 1, does not have any female issue of her own. So therefore, she on 24 March 1997, after consulting the clan member of Nokma family, had adopted the respondent number 2 while she was still a baby into her family, and there was no objection from any person including.
Okay, say one thing. Are you related to this? Does any of you can maintain a claim to Nokmaship from the people challenging the appointment? Apart from just saying that we are charas and we are not consulted, is there any other basis you're challenging the appointment of the respondent number 5? One simple question. You are challenging the appointment of respondent number 5, correct?
Yes.
Apart from only this allegation that you say that she was not properly adopted, any other allegation?
Yes, we are saying that at the time of
no, any other allegation, only adoption. That's the only allegation you have, that she was not properly adopted, correct?
That yes, that is number 1. And another allegation is that even the procedure adopted by the district council, because there was a dispute, Lordship, because they are saying
Mr. Piri Sama, you must understand one thing, that you're raising a dispute if this baby or this, now she's become Major Nokma, she was adopted around 30 years ago.
25 years ago.
25 years ago. Can you raise it now?
My lord, may kindly come the impugn order of CEM on para 5 and 6. Para 5 and 6, my lord, I will write, my lord, that he was not reading. That is very important. That the appellant do not have any blood relationship. The appellant has no blood relationship.
You don't have blood. But the thing is that
second thing, my lord, respondent number 1 has relinquished their right for respondent number 2. Once they have relinquished, my lord, and they left the Nokma house, my lord, how they can claim it?
No, Lordship.
Moreover,
one thing is even
Rimi.
Yes.
Rimi
is the rightful Nokma. We have no quarrel with her being Nokma, right?
With Rimi, we don't have, but we are having the problem, difficulty with her daughter.
So in her place, who do you think should come?
Because she there was no proper adoption.
No, but she was the last recorded genuine Nokma, correct?
Her mother was the last recorded Nokma.
Yes.
Now the mother, after the mother, the daughter comes.
Has adopted her.
That's why we have said that though she is the last recorded Nokma, but
25 years ago.
No, that because that adoption is not.
What is courts asking anything? You want to open up a matter 25 years ago, she was adopted, you want to open it now by depriving her, although she is nominated by her mother to be the new Nokma.
One of the aspect is even that present private respondent, she has also have willfully withdrawn that. I have enclosed the withdrawal petition also, Your Lordship. You kindly see the page 50. That's her own. Then we have already settled the matter also. See that application, my lord. That's why even in the order page this one, Annex 7 also, it is clearly reflected. Mother, she has. May I just read
Who wrote this for her?
Yes, Lord.
Is she literate? Can she write?
Yes, she is literate, Lordship. This is her application. She has read. This is written by her with her own. Yes, hand, Lordship, and submitted to the EMC. This is the. May I just read the type copy?
No need to read. Doesn't matter. You see, it's in own hand that I don't have LD mine or resign.
Yes. Then we have withdrawn.
I have a serious doubt about this letter.
Yes, let the private respondent reply to this. If she is denying, then that's
disposing it off. But then yes, heard Mr. P.T. Samala, counsel petitioner, issue notice. Mr. S.D. is present, except on behalf of respondent 1 to 3. Those issues 1 over 4 within 3 days. Yes, but it's the list after 3 weeks.
Lordship.
Otherwise, why this court was not to go because you can't open 25
in this matter, according to my understanding, affidavit will not be required. Only a record will be placed, my lord, because Mozada report, my lord. Once Mozada report is placed, my lord, whether the consent of the
just after 3 weeks, Mr. SD is also permitted to produce the records next date.
My lord, hello, please.
The relevant records next date. Yes.
Lordship.
Item number 5.
Yes, Mr. Khan.
Yes, Lordship, this is an application, Lordship, for restoring the interim order, Lordship, which was passed earlier. Lordship.
What happened? Just renew it.
Lordship, kindly see page 10,
There was
Lordship.
interim order. Where is that?
Page 10, Lordship. Page 10, this order dated 20/02/2025, Lordship. And the operative part is in the last para, Lordship.
Yeah.
If I may read, Lordship, in this view of the matter, at this
Has it been given effect too? It's order 21. In the meanwhile, no.
Not that I'm aware of.
Then we
In
renew
fact,
it.
if the respondents are here, we could have disposed of this
Where's the
matter.
respondents? They've been issued.
Lordship, it's fixed for steps, Lordship, because that main matter is fixed on 29, Lordship.
Yes,
that main matter. So,
come pick his last surname.
In fact, it should go back to the same.
Yes, for this miscase number 63, 2025, agency number 2042. Huh? Received. 6 is whom? 6 is Imam name. 5 is not received yet. This is an application for renewal of an interim order dated 20/02/2025, passed by this court in miscase number 23/2025, arising out of the PC number 42/2025. So it's submitted by Mr. T. Dakhar, the counsel petitioner, to the next paragraph. That this court will be satisfied that a prima facie case existed in favor of the petitioner had by order dated 20/02/25, passed an interim order keeping the impugned order dated 21/01/25 suspended until next date. Stop. However, subject due to inadvertence, he could not be present on last date, which has resulted in the said interim order lapsing. Therefore, prays that for ends of justice, the interim order be revived and the matter be taken for consideration. Stop. Next time, Mr. T.T. Dindo, Learned Counsel, Senior Counsel, appearing on behalf of responsible, submits the matters. The matter, the issue involves very limited, and if the party respondents are present, perhaps the matter could have been disposed of. Stop. However, perusal of the office note indicates that notice still yet to be completed on service yet to be completed on respondent number 5. So accordingly, this is matter. Accordingly, this miscase stands disposed of.
interim to continue.
By allowing the interim order to continue till the next date. Yes.
Obliged, also.
When the miscase, when the main case is fixed. Yes.
Deeply obliged.
Item number 6.
Lordship, I'll be filing my rejoinder during the course of day.
You have not filed it now also?
Yes, Lordship. Because due
Yes,
to her.
ML Talau submits the Jan final course of the day for this matter for hearing. Yes.
Obliged.
7.
Please, Lordship. Lordship, we need one more time, Lordship, to seek instruction.
Where's members B of Kharanlang?
Lordship, she's indisposed, Lordship.
She's supposed to argue the matter today.
Lordship.
So you're ready with the matter today?
No, Lordship.
Let it come up after 2 weeks, my lord.
Yes, on the prayer of Mr. Kriem, due to the illness of the arguing counsel, let the matter appear after 2 weeks. Yes.
My lord, interim may be extended.
Interim order, if any, shall continue.
Obliged.
Item number 8.
Your Lordship, we've received a copy from Respondent 1.
You are for the petitioner.
Yes, Your Lordship.
Yes. Number 1 is who? That is number 1 state. Yes.
Deputy Coach.
You file your affidavit.
Yes.
Yes.
We've received a copy. We won't be filing a rejoinder.
So what do you want to do? List it for hearing?
Proceed for hearing.
And what about the other respondents? You file affidavit. Then 4 and 5. 6. Who's Mr. E. Papang? 6 is who? Which respondent?
CWC.
Yes. Your name?
J. Rana. J. Rana.
J. Rana. MS J. Rana for the petitions submits that affidavit has been received from the respondent 1 and 2. She praised the matter with for hearing.
Respondent number 1.
1, yes. Just after 2 weeks, yes.
Item number 9.
For hearing after 2 weeks.
Please, Your Lordship.
Yes.
Your Lordship, the respondent was supposed to
Where's the
file
affidavit,
affidavit.
Mr.
My lord, I seek your indulgence, my lord. Can we grant me 2 weeks, my lord, to
How
file
many
it?
times you've taken?
Actually, my lord, in this matter,
Don't say someone else handling it.
no, I'm not the assessing counsel, my lord, because she's indisposed, my lord.
Who?
Eiling Wa, my lord.
Yes, 2 weeks for that time allowed for affidavit. Yes.
Deeply obliged.
Item number
For the
10.
time as please allowed for affidavit.
Please, George. For the petitioner.
Where's respondent number 8?
Respondent number 8.
You're appearing.
Yes, Your Lordship, for respondent number 8.
Then have you filed affidavit?
I'm entering appearance today, Your Lordship.
What do you mean today? Last time who's in Kharsono said that she submitted that she couldn't file affidavit as the petitioner is residing in Bihar.
I am appearing on behalf of respondent number 8, Your Lordship. I have just been newly appointed. I'll be filing my power today, Your Lordship, and I pray.
Where's the order of no objection of releasing the earlier counsel and engaging new counsel? Just a ploy to delay the matters.
We are
Right?
not aware about the
You're
previous.
not aware of the counsel? Who's in Kharsono?
I'm not aware.
This won't do. You can't. Number 7 is whom?
Number 7 is it's a bank, SBI, the Siri branch, Bihar.
Who's SK Joshi? This is a Bakalat issue to her. She is not aware. You contact the earlier counsel, otherwise.
Talk with the.
You mean your client didn't inform you that she had earlier counsel? No.
He has just handed us a power, and
This can't be done, yes. Though Ms. R. Kharshi has today submitted that she'll be representing respondent number 8. It was noted that on earlier dates, another set of counsels, namely N. Kharsono, another counsel, namely N. Kharsono, has appeared in a short time filing affidavit stuff. MS asked you to clarify the matter. Yes, when you filing affidavit,
We filed, Your Lordship.
you only filed.
Yes.
1 to 6 already filed.
Yeah, none of you has responded with 7 lists after 2 weeks of further orders. You clarified earlier, Councillor. He came personally to give you the power.
Yes, Your Lordship.
Very good. And now they're making prayer that he is resigning Bihar. We can't file affidavit.
Item 11.
Yes. We will ask for him to be. We have to issue a warrant of arrest, I think.
Yes, Lordship. In this matter, only private respondent number 7 has been appearing. That rest of the private respondent 5, 6, 8 and 9 still awaiting. We have sent it actually long by. We have even written to the
We
letter.
file affidavit indicating service.
That because we don't file it because she's already been appearing.
Who?
One private respondent.
5,
number
6, 8 and 9. Still last order.
So, yes, 5, 6. That one is still awaiting, Lordship, because we have not get the proper information
say
from
that?
this. Yes, Lordship.
1 and 2, you have 1 and 2.
1, 2.
Your Lordship, I am for respondent number 7.
Yes.
No, so 1 and 2.
And for the JHDC, Your Lordship.
1 and 2.
Yes.
1, 2 and 3.
You file affidavit.
Your Lordship, I would like to seek some more time to file the affidavit.
1 to 4. Who's 1 to 4? You're 1 to 4, that means.
Yes. She's 1 to 4.
Where's Mr. D? He was here just now.
He's on Lex, Your Lordship.
7 is you file your affidavit.
I need some more time, Your Lordship.
What's your name?
Idkar.
You're with MS Kiletep.
Yes, Your Lordship.
Your name, your
Yes, Dhar.
MS Isdhar response 1 to 4 and MS Idhar for number 7. Pray that we allow for a 2 weeks time to file affidavit stuff. This Mr. P.T. Sangma submits that digital service with respect to
5
respondents 5, 6, 8 and 9 that receive. He prays for and allowed. He prays for what? 2 weeks for the time to obtain status. No, not all prayers allowed. This about 2 weeks. Yes.
Must be Lordship.
Really a pleasure.
Item number 12.
Well, file.
We'll be filing in the course of the day.
Yes, Mr. Yara Khan, we asked it for submits that file course the day. This after 2 weeks for the joint of any. Yes.
I'll wait.
13.
Yes. You face referendum.
Before that, I'll make some submissions, Lordship. It's required.
No. What instruction have you got?
Lordship, so far as the customary practice in Nongpo Sirdarship is concerned, Lordship, it's not by way of election, Lordship. It's by way of nomination, Lordship, from the clan, Lordship.
You mean see the 10 electors have no rupee at all?
No, Lordship. It's by way of nomination, Lordship, from the clan, Lordship. And the clan, they still have the confidence, Lordship. Now, so far as, Lordship, we understand the anxiety from the other side.
Has that been recorded in Herbert's report?
Lordship?
It doesn't form part of Herbert's report regard to the manner of election. You know about Herbert's report, correct?
Lordship.
You know about Herbert's report, correct?
No, Lordship.
You know Herbert's report?
No, Lordship. I'm sorry, Lordship.
If you do matters regarding relations in EMships, there's a book which was made by this Colonel Herbert, I think in 1904 or something. He toured the entire Khasi Hills and documented the manner of election or nomination of these traditional heads. At that time, there were 25 EMships and some, Lindor ships. So Colonel Herbert's it's called the Herbert's report. And Herbert's report is the most, you can say, authentic also. Though acts have come where they've changed the manner of election or increased electoral college as done in Milliam, but that Herbert's report is like a fountain of knowledge. You'll know like in which way he went and interviewed, spoke to all these the elders as how elections were carried out. Papan Herbert's report is there.
I'll go
You never heard of it. It's very strange. If you're all doing sectional matters, you don't know Herbert's report. That means Herbert's report is, I think, 1904.
Now, that is one aspect of the matter, Lordship.
So we'll see whether is mentioned there or not.
Lordship.
Then you know whether it's by nomination election, because even all aimships know whether when they had electoral college, maybe only 1 or 2 mantris or lingdor nominated a chief, right?
Yes.
That is recorded.
My lord, if I can just one point,
Yes.
2 points I will point out. Now this is something altogether new. I
No,
have
it's
gone
altogether
between the
very
line.
interesting
Between the line in the writ petition, there is absolutely nothing, my lord. Lordship, after
Between
all,
the lines?
adjudicating the issue on the basis of the averment made in the writ petition.
Lordship,
Absolutely nothing.
The question of loss of confidence is only before.
Secondly, your lordships, the inquiry report, last inquiry report which was annexed by the district council, my lord will kindly come to page 12 of the inquiry report. He categorically submitted before the inquiry report there are 10 electors, and they have named those electors. Lordship will kindly come to page 12 of the affidavit filed by the district council, my lord.
I have in the miss case.
My lord, this is an affidavit bringing on record the inquiry report of the judicial officers. Now he participated, his contention before the inquiry officer.
This is by in the miss case.
This is, my lord.
Mr. Marpan, where was
Yes,
April
this is
5?
miss case, my lord.
Miss case number 218.
218. Yes, 218.
That's additional affidavit.
Additional affidavit. If I can take my lord to page 12.
One second. This is an affidavit bring on record inquiry report.
Yes, my lord.
And
First inquiry, my lord.
The exact list of voters.
Which he is saying, my lord, that we are reopening. Lordship will come to page 12.
Yes.
Second subparagraph, my lord, from the bottom. If I can read, my lord.
Yes.
He means the writ petitioner, my lord. He further stated that as per customary practice prevailing in Nongpur Siddharship, the eligible electors to elect the Siddhars 3 mintris and 7 lindors. The mintri shall belong to this clan. Insofar as mintris are concerned, he stated that he still has the confidence of the mintris. In fact, the mintri, by letter dated, has submitted clarification to the executive Elaga Hill District Council Shillong, showing the support and confidence on himself. As regards the eligible electors, my lord, these he has named.
How can he make a statement?
My lord, how he can take altogether a different stand, and there is no averment in the writ petition, my lord. Every day he is trying to bring some new facts, my lord, without making any.
So far as the loss of confidence, also that 24th September also
But
was.
you have made a statement at the bar that there's no election.
Lordship, this was before the inquiry officer. This was never tested or never.
No.
Lordship.
Can you make a statement at the bar as a council, not just to
Lordship,
protect your case?
that is as per
Can
instructions.
you make a statement at the bar that there's no election for MDC, it's all nominated?
Lordship, that is as per the instructions that I received from the.
What instruction by whom?
From
You
the
don't do any
petitioner.
cross-checking by yourself with regard to the facts of a case, how the history of any traditional institution or CMship or Sadarship is done.
That was done, Lordship, and we received the instructions, Lordship.
Mr. Nopur, you don't operate instructions of your client only. You're dealing with an institution, not a personal case, matrimonial case of a person.
Lordship, we understand.
It's not. You see this. What's your point?
What ones?
Librarian, what one?
No, I mean, search.
1904, isn't it? Then why do you make a
Lordship,
statement?
there's a categorical finding that it says that the court they still have the confidence, Lordship. Page 14, Lordship.
No, it's not that. You said you have made a statement that there's no elections. How did you come to office?
It's by way of Lordship.
Nomination.
Nomination, Lordship.
Yes, this is a council. How did he come to office?
That I have to clarify. But as far as the list,
Very serious submissions have been made by you.
Lordship,
that's
Lordship,
very
there are documents to.
You understand that you made very serious with regard to there's a code of
Lordship,
record.
So far as the
There's a code of record.
so far as the Elaka is concerned, Lordship, it's by way of nomination from the court, Lordship. Now
Then what are
that
these
the
electors?
resolution was
You know,
taken up
these
by the court,
electors are
and
there,
that
can I-
resolution was forwarded to the district council, and the district council has accepted the same.
The
And
electors were given a total bypass.
they are not.
No one in the picture.
No, Lordship. So far as this Elaka is concerned, Lordship.
Lordship, the affidavit itself is very clear. The electors mentioned the total number of electors. These are the people representative of the right who would come and elect the chief. Page 16. Lordship.
So you say that the Darbar Court CM Nongsha is the only authority with regard to to nominate a candidate or to nominate the CM?
The CM, Lordship. The CM, Lordship.
So they have to come to unanimous decision before they send for approval?
Yes, Your Lordship. Lordship, in fact, I have the proceedings in which the petitioner was nominated as the CM, Lordship.
Very interesting. You're taking it to a different level.
Now, so far as for the interest of the Ilaka, Lordship, the entire Ilaka is not here only. 5 linked doors are here before Your Lordship.
The Contempt what are looking for? Contempt what looking for? They don't know what they're looking for. So Contempt, huh? They won't know. They don't know what they're looking for. This is the one where you were reinstated. This inquiry report.
This whole case in the writ petition that we are reopening. It's totally silent, my lord, on this aspect. This is something new issue now he's bringing. Let him file a fresh
Even the
petition.
issue of lost confidence was new, Lordship. It was only filed in the affidavit, Lordship.
And that
It was
has
not
been
before the
clearly-
District Council, Lordship.
District Council order clearly reflected my lord loss of
And that is
confidence.
done
This
with
is the
behind my
ground for
back,
his-
Lordship. The copy was not served to me, Lordship.
My humble submission, my lords, at this stage, your lordship, my lord, admittedly 5 windows before your lordships, we have lost confidence on him, my lord. What we are asking, let the administrative take over, your lordships. It cannot go on. People are, at the end of the day, people are suffering. People of the Elaka are suffering.
Yes, the only thing that goes against you is that you have not filed an appeal against the order of reinstatement. You have re-agitated the same thing again, and he's not been given due opportunity. That's all.
Our contention to this is not only, my lord, that
We'll give you post hearing. Yes, let them be. Let you be heard again.
So far as the entire matter is concerned, Lordship, they have not filed any counter affidavit as well, Lordship. The main petition.
My lord, we are
Let them file their affidavit, Lordship.
We are mainly concerned with this interim order at this stage. He has lost the confidence, my lord. Will look into
Lordship,
it.
now the basic issue is, Lordship.
Still enjoy the confidence, but the thing is that
Lordship will not issue a read of.
And you see, we made.
Well, my humble submission will be, if your lordships, my lords, decline to vacate, that amounts to, my lord, asking us, my lord, to directing us to repose the confidence on this person. That, my humble submission, this court cannot.
I don't think they can. Library knows what document is also. Library knows none. Huh? What? Because it's done all same shape. I don't know what it's done for Nokma or not. Nice. I was off by 1 year. It's 1903. No, regard to Nokma is not there. So anyway, yes.
So my humble submission, my lord, in this case, my lord, there is a case of loss of confidence, basic elementary, my lord, democratic principle involved here, your lordship. That is to be upheld. Secondly, my lord, the people are suffering, your lordship. Let the administrative take over, my lord. Now my learned friend every day raising a new issue. Now he has come up, he is nominated. There is not a whisper in the writ petition. Now if he wants this issue to be decided, let him amend the writ petition. But my humble submission, lordship, will vacate this order at this stage. There is not a whisper, my lord, in the writ petition about this. Because ultimately, my lord, whatever, my lord, interim order is passed based on the amendments made in the writ petition, my lord, not beyond that. Now he cannot bring something new where there is no pleading in the writ petition.
The only thing that's there, Mr. Sen, is that it's against on the same, is more or less on the same allegation. You didn't
More or
take part
less,
in
my
inquiry.
lord. My lord, I can suggest one more thing, your lordships,
Yes.
because
Section
6, my lord.
In office, then inquiry continue against him.
Yes, my lord. Inquiry they can go and
Will not-
represent.
will
So
not-
far,
will
the
not
administrator
suspend
let
him.
it take over.
That's
Let him
amount
face
to
a fresh inquiry.
Lordship, that amounts to
That my
reopening the
inquiry
same
part,
issue.
lordship
Lordship.
can examine.
So
But
I
so
can
far,
show
my
you,
lord,
Lordship, that is the same complaint, Lordship,
my
same
lord,
allegation,
administration,
Lordship.
my lord. Let
You
the
face-
administration.
you face inquiry.
I am saying that,
Yes,
Lordship,
step in
the
whole issue,
same,
you face-
the
you face
complainants,
inquiry, you
the
face-
allegations made in the second complaint is same as that in the first inquiry,
not
Lordship.
correct.
Lordship, I have already faced the inquiry, Lordship. That will amount to reopening, Lordship.
They didn't take part in inquiry.
Lordship, it's for them, Lordship. They'll have to challenge that order.
This
Their
order,
remedy
the order
available to
stands
them.
with the order.
The inquiry report, my lord.
Yes.
That is in the affidavit of the district council. 218.
That means you are operating with independent of the Darbar, Mr. Nampur.
Yes, my lord.
There's a Dorbar, Lordship.
That means you're not
There's a
beholden
Darbar,
to them. You're not elected by them.
There's a Dorbar, Lordship. There's 12 members,
So
Lordship.
you're not beholden to them. You're not elected by them. They're not electors. You say you're nominated.
And so far as one of the members is concerned, he represents the Dorbar. He represents the Dorbar Kuru, Lordship. He's one of the member of the.
No. That means that means your submission number one. You're not elected. You're nominated. No one has any right to no one has a right to question your appointment. Once done by that Nongshai clan, it goes for approval. It's automatically approved.
Lordship.
Right.
Lordship.
And the Darbar here is just Darbar
To run
for
the
consultation.
administration, Lordship.
That means they have no right to question your functioning also.
No, Lordship.
No right.
No right.
Suppose you do any draconian kind of act, no right to question you. That means you are totally got unfettered authority to do whatever you.
No, Lordship. Lordship, I'll be bound by the terms and conditions of the Sanat, Lordship. Of the Sanat issued by the district council.
No, if someone can't make a complaint against you, then what is the point of them being a complaint then?
Lordship, because the complaint are from the Lingdo, not from the people of the Laka, not from the Kur, Lordship.
Why would the court complain against you?
Exactly, Lordship. So far as the people.
This is one of I have practiced a lot of this law, so it's the first time I've heard this kind of this submission that you're not accountable to the Darbar. You know that the traditional head can't function on the Darbar, consent of the Darbar.
That is true, Lordship.
Then you think I don't need the consent just now?
Now, so far, no, Lordship, because they are saying that the
No,
electors.
come clear, you say you don't need the consent of the Darbar
Lordship,
in a functioning,
statement-
correct? You don't need the consent.
Lordship, the statement made before this court is that.
Okay, I'll just
they are
one
the
question of the
electors.
court. Now, when you sign an order alone, is that order effective or not?
Lordship, there will be a proceeding. And
No, is that order effective or not? Suppose you sign. I'm just putting a question. Since you see that suppose you sign order, is it effective or not? Does it amount to an order of the Sardar? Or is it
So that will be
ineffective?
subject to the because there will be a proceeding and subject to the.
No. Will you sign one? How is it signed? How is order signed? By AMs, by chiefs? How do they sign? This is customary law. How is it signed? When it's signed? How is it signed?
Lordship, that will be from the after the proceedings of the Darbar, Lordship. Perhaps any decision will any letter that has to be signed or any order has to be signed.
Correct. You signed as CM Darbar will sign. As CM on his own cannot sign anything also. Correct.
Lordship.
So he signs on his own. That's your submission.
Lordship, he signs.
See, he doesn't need
not
a
on
concurrence.
his own.
That's your
Lordship.
submission
Not,
today.
not on his own, Lordship.
He said he doesn't need a concurrence of
Lordship.
Darbar. He's not elected by these link doors also.
But to run the Ilaka, there's a Darbar, Lordship. Now, so far as nomination goes, only the election is concerned, Lordship. It is only by way of nomination, Lordship. Now, so far as how to run the administration,
Nomination, even suppose as AM clan can nominate anybody, but that doesn't depend that the approval be automatic.
Lordship. Now, the Darbar clan has to nominate one person from the clan, Lordship. Now, that will be subject to approval.
So once they nominate, that means they only other ones can give no confidence.
Lordship, exactly, Lordship.
That's your submission.
Lordship.
Lordship, I'd like to submit, Your Lordship. In fact, the petitioner was in fact an acting Sardar. That is in Section 1, page 22. Now, in the acting Sardar, there's nothing about he being nominated or nothing. You can go through the content of the page 22, Your Lordship, where he was appointed. This is the type copy, Your Lordship, where he was appointed as the acting Sardar.
Anybody can be appointed. That's not hard and fast rule.
And also the confirmation.
Doesn't have to need from the clan also.
Exactly.
Page 25
So
is
these
my
are all
Sanat,
done by
Lordship.
the district council, EC,
Page 25.
appointed as per the Act of 1959. So he was appointed by the Act of 1959. He is bound by the provision given there.
Interesting because he's twisting
So
it.
whatever statement is given that he has been.
Page 25 is my Sanat.
It's nowhere in the appointment letter.
Page 25 is my Sanat, Lordship.
And when he was suspended also, nothing as such. And in the show cause also, he had never raised this. He had never pleaded that he was nominated or whatever the case may be.
Because the show cause is based on the question of reinitiation of the inquiry proceedings, Lordship, not on the basis of loss of confidence.
And subsequent suspension also, Lordship. But the last occasion also I've pointed out, I've stressed. One fact is that his subsequent suspension did not happen because of those 3 letters of representation or, for that matter, a complaint. If you consider that, we have based it on the written submission after the hearing.
Lordship, whether written submission is the complainant, and that itself, that copy was never supplied to me. It was the proceeding itself was.
You have Mr. Nompure on national justice, nothing else.
Lordship.
Not on your election, anything.
The written argument, based on those 3 written arguments submitted by the complainant and the petitioner, we have come to a conclusion where Section 19, to invoke Section 19 was necessary because there was a deadlock. In fact, an inquiry officer has already been appointed. He is on standby. In fact, they have already received a notice, but we have issued another notice to keep that in abeyance pending this present proceeding. Administrative officer is also there.
We'll pass orders then, yes. Obliged.
Roger.
You have a look at this here.
Lordship,
you're not aware of this service report. See.
Item 14.
Yes.
May I please, Your Lordship? Your Lordship, I am praying 4 weeks time for filing a.
You're Mr. Devnath?
No, Your Lordship. That's I'm appearing for on behalf of Mr. R.K. Majumdar.
Mr.
R.K. Majumdar.
Item number 14?
Yes, Your Lordship.
Your phone number 4.
All respondents.
All respondents. Yes, MS B. Ghosh, praise for how much time?
4 weeks time, Your Lordship.
For the 2 weeks time is allowed as praise because this matter has been hanging for a long time.
15.
Highly obliged.
Yes. Yes. Yes, what do you have to say?
Your Lordship, the conducting counsel is on legs.
Call him now. We'll pass the time me. Call him now. Where legs? No other court sitting also.
16.
Yes, Mr. Jha.
My lord.
File.
No, Your Lordship. I'm praying for some more time, Your Lordship. 3 weeks' time.
When was this file?
My lord, 2024, my lord.
3 weeks time?
Yes, Your Lordship.
Was for 24, 25? 25, 11, 2. Yes, 2 weeks for that time as prayed.
Highly obliged, Your Lordship.
17.
May it please Your Lordship. Your Lordship, I pray that this matter may come up after 2 weeks, Your Lordship, as the learned DSGI is out of station.
Slight objections are there, Your Lordship. Since
They are supposed for interim orders. What's the matter about?
Your Lordship, this is the termination of service. Meanwhile, similarly situated persons have already received interim protection. Yes, Your
When
Lordship.
is he coming back?
He'll be coming back next week, Your Lordship.
Instructions. Even if he's not here, instructions should be obtained.
I have no instructions, Your Lordship, right now.
But it came for a long time, correct?
Yes, Your Lordship.
Yes, Mr. Singhon.
We are just a formal party in this.
You're a what?
Formal party only.
Formal party. You are serving as?
He was serving at West Khas Hills district under the Agmut scheme,
You're
which
number
is
3. Yes, MS. As Emre Chiang expresses her difficulty today due to the absence of the DSGI. List after 2 weeks expected next date instructions to be received. Yes.
Highly obliged, Your Lordship.
Item 18.
May it please Your Lordship. Lordship, in this matter, I need some more time, Your Lordship.
What's the matter about?
This is Home Guard's revision of pay, Lordship. This is covered by
the
the
last person who was left out?
Yes, Lordship.
Yeah, initially.
Let it be 2 weeks' time, Your Lordship.
Pray for allowed 2 weeks' time to obtain instructions.
Oblige.
19.
Yes, served.
Yes, Your Lordship.
4 and 5. 4 and 5.
Yes, Lordship.
Yes.
Your Lordship, as per the last order, Your Lordship, I was supposed to file my additional affidavit to bring some material, Your Lordship.
You filed it?
Yes, Your Lordship.
Where's the additional affidavit?
Your Lordship, I filed on the 4th April, Your Lordship.
Yes, when are you going to file affidavit?
Well, I will pray for some time, my lord.
Yes, just take
Your
down
Lord-
additional affidavit has been filed being on record. An objection dated 10/12/2018.
For respondent number 1, 2, and 3, my lord.
And this has been filed by the petitioner, bring on record the objection filed before the executive member in charge land revenue regarding appointment of the
Yes,
which
yes, Your Lordship,
respondent?
they are
Which respondent?
It is objection appointment. Who this is?
respondent number
Rajan,
4.
Rajan Sangma. His number?
Respondent number 4, Your Lordship, had filed.
1 second. Are the parties here?
Yes, Your Lordship.
No, who is class 1 and rolling? They are parties here also, Rolling Stone.
Yes, Your Lordship. He is respondent number 4, Your Lordship.
Okay, yes, after bringing on record objection filed by respondent number 4. Stop to the appointment of Aking Nokma. Stop. After indicating service on respondent number
4 and 5.
4 and 5 also been filed. As such, service is complete. Stop. Is Mr. Nokma SD praised for? It's allowed 2 weeks time to 3 weeks time to
3 weeks.
Your Lordship, I have filed a miss case, Your Lordship.
For interim orders?
Yes, Your Lordship.
What is the miss case?
Your Lordship, miss case number 53 of 2025.
Yes.
Since I have received the additional affidavit today itself only, my lord.
No, you kindly you
Just
put up next week. Just examine. Yes, yes. Ms. SD prays for 3 weeks time to file affidavit stamp. Stop. And however, MSEDC and the counter petitioner has submitted that there is a miscase will pray for interim stay. Taking that into consideration, this matter after 1 week for consider interim prayer and to enable appearance of respondents number 4 and 5. Yes. Miscase this after 1 week. Yes.
Item 20.
You kindly examine the miscase whether you will allow or yes, Mr. Sama.
His Lordship, they are supposed to file some document which is the constitution of the IO owned, which they have made a submission on 11/2000. They said that the counseling authority was constituted on the 11th. They have not.
No, I'm just praying for more time, Lordship.
1 day's time.
On behalf of learned AG.
Yes, Mr. Khan. 1 week's time.
Lordship.
Please, I thought just 1 week's time to bring on record the
constitution of the
constitution of the Meghalaya State Counseling Authority, which was very good. By order dated 8/4/2025, this court allowed the learned EAG to place by way of an affidavit the constitution of the Meghalaya State Counseling Authority. Stop. Today, Mr. A.R. Khan submits and prays on behalf for the 1 week's time. Praise allowed. It's expected next day that affidavit should be on board. Yes.
21.
Please, my lords. This is the tender matter from the health department where my lords were pleased to, my lords, direct the state to file an affidavit. At that stage, my lords had not considered an interim prayer, but my lords had directed that the state file an affidavit within 1 week to clarify the position with regard to the corrigendum.
What happened to corrigendum?
Lordship, as of right now, I've been informed that they haven't opened the tender yet, Lordship.
That doesn't matter. Just clarification. We have not allowed them interim orders.
Lordship.
We are suspending tender process.
Lordship.
What's the clarification?
Lordship, I still didn't get any instructions yet. Lordship, I require for Lordship, matter can be taken out on Monday. Lordship, I can find my.
Monday court's open.
Tuesday, Lordship. Sorry, my apologies.
Tuesday, Melons.
22nd.
21st, High Court holiday.
Yes, Lordship.
Melons. 21st is not a working day. I have it on 22nd.
Where's the Advocate General?
Lordship is in Delhi, Lordship. Lordship, he'll be coming.
This is man 22nd.
22nd. For the affidavit, my lords, my client clarify.
Clarificatory. For the affidavit of clarification.
That's because at that stage, my lords were not pleased to stay the tender, my lords. But
let us see what they clarify.
22.
Nice.
Any wanton felling of trees?
Lordship, as per my instructions, they have been patrolling and in that area, Lordship. Regular patrolling and regular watch.
So what's the report?
Lordship, as per my report which I received, Lordship, I just share if I can produce the records which I've received from the department this morning. Lordship, if I can take your Lordships to the last page. May I read, Lordship?
1 second. So you're doing regular patrolling?
Lordship.
Counting the trees that have been felled?
Lordship, I'm not. Lordship, but then as per my instructions, Lordship, as page number 3, Lordship, the case has been filed in section 5 of Meghalaya Trees Preservation Act.
Mr. Marpan,
Yes,
you
Lordship.
take it our authorities. We will disclose this petition. You already filed a complaint offence report as per the records of
Exactly,
since
Lordship.
October.
Yes,
Yes,
but action was not taken. But
Stage
again,
Government
the
today
continuous,
has
Lordship,
produced,
the continuous felling of trees that
produced a set of
still
documents, set of letters indicating the fact that the writ petitioners have approached the forest authorities since last year with regard to the subject matter.
Lordship, the last complaint
Some
is
action has been initiated by the forest.
December.
By the divisional forest officer in this regard. From the documents produced, it is seen that the divisional forest officer has instructed regular patrolling duties. In his view of the matter, has been towards this stage, allowing the petitioner to pursue the matter before the. Also is,
Lordship, if an observation is also made that if there is any illegal felling of trees,
see, the thing is that the thing is that Mr. Marpan, now felling is being done also in some areas under due permission. Now suppose you have no title to the area, you go and
mainly on the focus of
There's something that's relevant to this. That's why I had to check. There's an order passed by the division bench of this honorable court, where all felling has been stalled. So there's no question of any permission being granted by anybody for felling.
So what you do is you pursue the authorities.
Lordship, the order before division bench is here, Lordship. He can, if the petitioners anyway agree, we can plead himself before the division bench, Lordship.
Not necessary. You take the division bench or take it to the forest officers.
Lordship, all this in the line of the writ petition 306 2017.
We will not see anything. You take it up, yes? But can push the matter for the authorities come. It's also mentioned by the government advocate that additional senior advocate that their orders operating from the division bench of this court. Passed in?
Lordship, PIL number 2 of 24, Lordship.
PIL
Dated
number? PIL number?
2 of 24.
2024.
Dated 9th April 2024.
Yes. To which the petitioner can take recourse to. Yes. Like paragraph matters at these times closed at this stage, with liberty to petition to seek appropriate remedy. Yes.
Second call 15.
Yes. Call Mr. Day.
He's outside.
You called him. That's what he's outside. He wants to submit from outside. Yes, Mr. Day. What was the matter?
I've seen that complaint which was lodged against my client. But let the affidavit come, my lord, because
inquiry report is there.
My lord, because
inquiry report generated by the Lokyokta, right?
My lord, yes, my lord.
Has a grave bearing on your case.
Yes, my lord. But Lokayukta is not functioning at present, my lord, because we lodge a complaint.
It's functioning, only that the person is not there. The office is functioning.
The office is functioning, my lord. Only thing is this, my lord. My grievances was, my lord, that we lodge a complaint before the deputy commissioner. That complaint has not been addressed. These are all offshoot of this matter, my lord. What I understand. But my principal grievances was this, my lord. My complaint, which I have lodged, has not been addressed, my lord.
Lordship, report of inquiry, Lordship, some people, Lordship, they have...
Copy. You might be having a copy, but you said because last time whoever appeared said that we're not aware about this inquiry.
So let them give us a copy, my lord. I was told only, my lord.
Lordship, this
you
fact
can get
also...
a copy from the Lokyukta.
Even this fact was concealed, Your Lordship.
No, it was not concealed, my lord. Yeah. It is not correct that it has been concealed, my lord. That senior has weapons in his hand, he can fire, my lord, but not concealing the fact.
But were you aware of this inquiry?
Probably, my lord, that is what instruction I need to take from the...
Exactly.
My lord.
Was the petitioner aware or not?
My lord. I will take the instruction on this specific instruction, my lord.
Yes, aware, Your Lordship.
Next week, yes.
My lord.
Mr. SD please be allowed 1 week further time to obtain specific instructions,
my lord,
as to whether the petitioners are aware of the proceeding for the Meghalaya Lokyukta.
Hearing, item 23.
Come on, answer the motion. Okay, the 23.
23.
Yes.
Are you there in 23?
Yes, sir.
Huh?
May it please your lordship. On the last occasion, the respondent number 4 has raised question with regards to the date of death of the first wife of her deceased husband, as well as the date of marriage between me and my deceased husband. Your lordship, the petitioner in this case is before your lordship for family pension, which is a statutory as well as a social welfare benefits accruing from her status as a wife of the deceased. It is undisputed fact, your lordship, that the petitioner had a son with the deceased, which is in the birth certificate of the son is in page 22 and Annexure 3 of my writ petition, your lordship.
Yeah. Who was the paper of the state?
I'm there, Lord.
Last time there's nobody.
No, I was there, Lord.
Oh, you were there?
Yes, I was present, Your Lordship.
R4 Kumar is?
Yes, it's me, your lordship.
You're for R4, correct?
Yes, your lordship. Your lordship, it is also undisputed fact that I've been staying with my deceased.
No, we're not going to go. Just see what the last order say. Today, MS so-and-so, like counsel is going to first produce birth certificate of the other child of the deceased employee.
Yes, your lordship.
Major. Upon hearing the counsel's questionable documents and disputed facts have arisen, especially the date of demise of respondent number 4.
Date of demise of the wife of the
Wife
of the first wife, Your Lordship.
Respondent number 4 is the?
My mother, Your Lordship.
She died.
Yes, sir. Expired.
1 second.
Lordship, if I may pray, Your Lordship.
Chika Lama is whom?
It's respondent number 4. Here I'm a minor, Your Lordship.
Who's Maya Lama?
Maya Lama is my auntie. I'm being represented by Maya Lama since I'm a minor, Your Lordship.
This is sorry, incorrect. Demise of the mother of respondent number 4.
Yes, Your Lordship.
Right.
Mother of respondent number 4.
And there are marriage deceased employed with the petitioner.
Between the petitioner and the thing.
These are the facts which can be ascertained before this court.
Yes, Your Lordship.
With the documents that have come, we don't know.
But Your Lordship, the
date of
facts
death
remains that I'm his wife, Your Lordship, and I have a son, Your Lordship, from his decease, from my deceased husband.
Yes, sure, what are you saying?
Lordship, my humble and respectful submission, Your Lordship, there are rival claims and the issue also involved a disputed question of fact.
No, that is why.
Let them go and approach the Supreme Court of competent jurisdiction. If they can settle, Your Lordship, then...
The fact, Your Lordship, that initially they agreed for
Ms.
settlement,
Rasiya,
Your Lordship.
The thing is that the points they've raised and the counter arguments have been raised, you'll need evidence.
Lordship, sorry, absolutely.
And need evidence because the court sitting now here, we cannot, understand from the documents as which is the right document, the date of death, then your
Your
factor of
Lordship,
marriage.
I'm not here for the date of death or anything, Your Lordship. I'm for family pension, Your Lordship. I'm for my stand is that I'm his wife. I took care of him, and I perform his last right. I have a biological son. Since it's a social legislation, social welfare benefits, Your Lordship. Being his wife, I am entitled to the family pension, Your Lordship.
See, the thing is that he was married to the mother of the respondent before, correct?
Yes, Your Lordship.
And
After
now
she
she's still a
died.
minor. And her mother died, right?
Yes, Your Lordship.
The first 5 PDC is the deceased employee, correct? Now, after that, then you married the...
He married me.
Now, what's happened now is that now they are conflicting facts with regard to, the documents that have been given, they're all disputed facts. How do you expect this court to decide that?
Here, not only one document, Your Honor, but in fact all documents are disputed.
All documents are...
Your Lordship, I've submitted a marriage certificate.
That
Your
does not
Lordship.
matter. See, we'll not go through documents again, correct? Because they're all different dates. Where is that? That was shown.
But Your Lordship, the fact that I have a biological son, my son is entitled, Your Lordship, to the equal share to the family pension. The title suit, Your Lordship, will take a long time, and I've already made to suffer, Your Lordship.
But sometimes there's no other way.
But Your Lordship,
See,
since...
it's very clear cut that yes.
Your Lordship, since, if not for me, Your Lordship, at least for my son, Your Lordship. Since...
They also got a minor son.
Yes, Your Lordship. We are agreeable to 50-50% share, Your Lordship.
Because we had heard this at length. Because you gave one match from Nepal and the other one from?
Both from Nepal, Your Lordship.
Both from Nepal on 2 different dates.
Correct.
The one which I've submitted before the office, Your Lordship, is the exact one, Your Lordship. And the previous marriage certificate was submitted by my deceased husband.
It's not true, Your Lordship. Here all the documents was submitted to the office after the demise of the deceased employee, Your Lordship.
How will this court decide? It's not that they don't want to give you relief.
I understand, Your Lordship.
But then it becomes difficult.
Only on the basis of my son, Your Lordship, since the birth certificate is there. And Your Lordship, a residential certificate was also there that they have been living together.
That as well, the court cannot decide this matter because one he married in 12, right? And the other he got married on.
First marriage, date of marriage is 2006, Your Lordship, and thereafter they have corrected and made it to 2012. Because in the year 2006, my mother was very much alive.
Your Lordship, but the fact that my
That's
son was
exactly-
born in the year 2014 shows
I'm
that.
sorry, I'm sorry, I'm sorry. Because the court can't give a definitive finding. So we can't just, overlook everything and say that, that it's fine, that, you're entitled, since we don't even know. How can we sit here and see who's, when you married, which correct
But Your
date?
Lordship, the birth certificate, Your Lordship,
You
of
file
my
a
son,
suit.
my father's name is reflected.
Are you a citizen of Nepal or India?
I'm a citizen of Nepal, Your Lordship.
Then how can she claim
But
the rights
after I'm got married to my deceased husband, I came to India and stay here, Your Lordship.
Your Lordship, here India does not support dual citizen as well as Nepal.
It's not
If she
about
is
dual
if she
citizen,
is-
Your Lordship. In 1950, the Nepal has signed a treaty with India, a peace treaty, Your Lordship, where Nepal citizens can get married. They can
That's
have
all
a
right.
friendly relationship.
But see, it has not been established with regard to, the why. Why is the doubt created in the mind of court? If there was one marriage certificate also, which showed the same date, correct?
Yes, Your Lordship.
Where you produce one marriage certificate for authorities that was married so and so, there's one marriage certificate that can be corroborated also. That can only be done in a civil court. Now you've given two marriage certificates
But Your
with
Lordship,
different dates.
but
Then-
Your Lordship, keeping the marriage certificate aside, Your Lordship, the birth certificate established, Your Lordship, that the deceased employee had a biological son, Your Lordship.
Very difficult. Last time it took time to prepare the case better.
Yes, Your Lordship.
We're still the same page only.
But
Yes. What to do? Yes, should I? Can a department take a call on it?
If both of them agree, Lordship certainly
You
will
go
do
before
it.
the department.
initially they agreed, Your Lordship, for settlement. Yet
you-
if they have any objection with
Then you
regards
let
to my
you
marital
cut-
status,
see,
Your Lordship, they
so
would not.
before title suit take too long, what you do is you take down. Today, Ms. Arkhashing has renewed her prayer for equal share of the terminal benefits on the ground that, notwithstanding the authenticity or genuineness of the marriage, the fact that remains is that the petitioner had born a son.
may I please, Your
No,
Lordship?
that's her submission.
Okay.
Had born a son from the deceased employee, and as such, the child born of such union is entitled to some, benefits, terminal benefits. Stop. Ms. Karkumar has strongly, vehemently objected to the same,
With regard to the birth certificate of the son as
and
well,
have
Your Lordship.
even questioned the veracity and authenticity of the birth certificate. Stop.
Because the name appearing in the birth certificate is not of hers, Your Lordship, it's someone else.
Doma Lama is my nickname, Your Lordship. Maybe in a hurry or.
Amna? The birth certificate and has submitted that the name of the mother recorded in the birth certificate is not of the petitioner. Stop. Next one, as observed by this court in its order dated 26/2025, in the face of such questionable documents and its disputed facts, this court sitting to jurisdiction cannot give a definitive answer or to settle the competing rights of the parties. Stop. Next paragraph, Ms. Andy Shulai, Learned EAG, has however, can we record that?
Lordship, yes, if they agree, we will not
That if
stand
the
on their way,
parties
Your Lordship.
are agreeable, perhaps the matter can be attempted to be resolved at the level of the department itself. You don't object to that, correct?
No, Your Lordship.
So the same not objected to by the parties, as it will avoid the hassle of avoid the burden of filing of title suits. Considering the matter in the totality of circumstances, in considering a matter, the suggestion as given by learned EAG and the consent given the parties to try to work out an amicable solution, this matter shall stand disposed of, giving the authorities a period of 2 months to come up 2 months to dispose of the matter. It's expected that both the parties shall cooperate fully and shall cooperate fully with authorities. This matter stands disposed of. Otherwise, impossible to decide. Yes, next.
28.
No, 28.
Over and this was 0.
27 and 28.
28.
No.
27 and 28.
Lordship, may it please your Lordship. Lordship, item 27 and 28 are.
Yes, who took time in 444? Who is there? Dr. Mozika?
Yes.
You have taken time, 27, 28.
No, Your Lordship, but I intend to pray for time for item 28 now, Your Lordship.
No, 27, 28 are tagged together, your Lordship.
They are not connected matters, sir. Different cause of action.
27. But Dr. Mozia is appearing both the matters.
Yes,
and
Your
he's
Lordship.
not here. How do we
Let
resolve
it
that?
be fixed, your Lordship, if my friend agrees, and then we'll have on.
Yes,
on
Mr.
a
Pasi, you come to
on
Shillong.
certain
Why you
date,
will
your
sit in
Lord.
Tura only?
Now there is a facility of video conferencing.
Yes.
Actually, so many documents are to verify, so that's why it's
This-
not possible for video
Sometimes,
conferencing.
your Lordship, we have some glitches in the connectivity of.
You get a fixed date, you come next date.
You should
You're
you
supposed
take a
to always-
date.
With,
Your Lordship, that matter can be fixed on the 25th.
well, okay.
25th.
25th.
April.
25th of April. Yes, he'll be back.
Yes,
As
that can
per- on submission of the parties, this matter as a fixed item on 25th April 2025, both matters.
Lord.
Yes, next matter.
Apply, your Lordship.
Item 30.
What about sign? Benar kan? Sini tak? Ask which case record and ask which one. Oh yes, 2023. Yes, 23 is report. Yes. Yes, Mr. Sheikh.
Yes, Lordship, here, my lord, here, the petitioner's father, he had owned several plots of land, measuring around 52 bighas, Lordship.
Yes.
52 bighas, that is at page 6, para 2, I have given the details of the plot number, Lordship. Now, the petitioner's father,
Page 6, so to the orders. So where?
page 6, para 2.
Oh, sorry.
This is the in the pleadings, Lordship. Now,
So he has 19 plots of land.
yes, Lordship. Totaling that area is 52 bighas, Lordship. Then his father died on 3rd June 1998, Lordship.
Yes.
Leaving behind the petitioner and the respondent number 8, Lordship. There are 2 sons, no daughter, Lordship. Now, in 2006, Lordship, 2005, the petitioner filed an application before the District Council, Lordship. That is at page, Lordship, you will find the type copy at page 22, Lordship. For mutation,
This is
Lordship.
28/7/2006.
Yes, Lordship. 28/7/2006.
Okay.
Order dated. The type copy, because the original copy is not legible, Lordship.
Yes.
The type copy has page 22. I'll just read from para 2, Lordship. The para 1 is the details of the plot, Lordship. Objector has filed an objection. That is the respondent, Lordship, here.
Now your brother's name is what?
My brother name Kamini Madak, Lordship.
Now you only 2 brothers are there.
Yes, 2 brothers. There is
Now you
no
have mutation in your name.
No, I said that yes, it should be half should be in my name and half, because the property cannot be remain in the name of a dead person, Lordship.
Of course.
Now, Lordship, here he filed objection, and the operative part will find, Lordship. Next page, Lordship. Statement are taken and recorded from both the parties. Objector Kamini Madak in his statement stated that all the lands standing in his father's name were given him during his lifetime of his father and cannot apportion it with his brother Sunil Madak, the petitioner. The petitioner Sunil Madak in his statement has...
Yes.
Petitioner Sunil Madak in his statement stated that he is the eldest son in his family and his younger brother Kamini Madak, the objector, cannot claim all their father's landed property and claim that he is paying land revenue to district council regularly. This is the operative partnership. I have perused the records and it reflects that the brothers are contesting for their father's landed property, which is covered by above.
One second. Yes.
Sorry, Lordship.
No, yes.
Above mentioned patta numbers measuring an area 52 bigha, 4 kata and 17 losa, and the eldest son Sunil Madak, the petitioner, is paying the land revenue for the said patta land to the district council and produce revenue record payment of so and so number so and so. Further, it appears that they are the only 2 brothers in the family and they are from the Hindu family. Hence, in my opinion, the objector Kamini Madak cannot claim all their father's landed properties. I therefore, considering the above circumstances, the proceeding of mutation is suspended and the 2 brothers, Sunil Madak, the petitioner, and the Kamini Madak, the objector, are advised to make proper apportionment of their properties, father's landed properties, among themselves. Now, after that order, they are not doing, Lordship. Then again, I have to come again before the same authorities, Lordship. That is at page, Lordship. Next page, Lordship, 24, Lordship.
Yes.
That order is 19/3/15, Lordship, 2015.
Yes.
The mutation case record is put up for hearing. Heard the submission of the learned counsel Sri M.L. Thangal for the petitioner that this case is the outcome of the objection raised by OP, which is applied to mutate the land and area 26 biga, that is my half share lordship, out of 52 biga 1 kata and 17 losa of patta numbers and dag numbers mentioned in the petition of Sri Sunil Madak, petitioner son of so-and-so. He has submitted that the then revenue officer has directed both the parties, the petitioner and the respondent, to divide the landed property equally, that is 50% each of the total area of the land left by their father among two brothers by this order dated so-and-so, that is referring to the earlier order lordship. He also submit that he has seen the objection made by Sri so-and-so, Kamini Madak, not giving the landed property of his mother to divide the land in question, where the order of the land revenue officers has passed an order to divide the landed property equally among two brothers. As per law, Sri Kamini Madak has no any right to object the permutation of his land in this court, as because the same revenue court has passed an order to divide the landed property equally. Moreover, it is not objected or appealed against the prior order of the court. So his objection for mutation of this land cannot be entertained, and the mutation can be allowed as per the prior order of the court and otherwise and other following grounds. Here the grounds are given, lordship. No will is written to any party by their father. No will is shown during the cause of court business. Will is not exist. Objection for mutation is raised only when the petitioner applied for mutation after long years without any order of the appellate court. The objection is raised by the learned counsel for the opposite party that the will is in favor of Kamini Madak, and his elder brother Sri Sunil Madak is staying away from his younger brother after taking away of his share. He also submitted that will which is written to anybody in a good faith cannot be denied by someone. The will is an expression of one's willingness to give something to other who is loved by him or her, and when will is given in a written form to someone, it is valid and genuine or for that particular object. Sri Kamini Madak is the sole supporter of his father in the family. As such, he got a will of his father for landed property. He also submitted that the then revenue officer had advised to apportionment of landed property of their father equal among the brothers. The property of late.
Mr. Day, what was the other record? The suit was filed by Kamini.
3 mile first.
Okay, fine. Now your prayer here is only for you. You're maintaining the same prayer you made in 2006 or 2015 for issuance of joint patta,
yes.
Correct? Fine. Then
my lord, it is not.
What is one number 4 that represented here?
My lord, what happened?
Served, right?
Yes.
He first filed CRP. There are subsequent orders also, lordship. Against those orders, he filed CRP, and CRP was withdrawn. Then again he come to High Court, filed a second writ petition. That was also withdrawn. Liberty given that you. But in fact, there was no will at all.
No, that is not correct. That will was not there, my lord.
I am not saying.
My lord, one document has been.
I am not saying this is record saying.
Then why didn't he file a suit and produce? Why did he go for probate of that will then?
That is what, my lord. But what has obstructed us not to issue the joint patta, my lord? Because one will he has produced, my lord. This is the will.
But that will
it has not been probate. That is the position.
The thing is that.
Yes.
And
now,
one thing,
because of that, my lord, we thought
yes,
that my lord maybe he has filed a probate suit, my lord. He has not filed. That is what we have.
Then he go ahead and mutate it.
Yes, my lord.
Because now, mutation,
my lord,
recording of name record of rights. That's the first title.
Let my lord then let me a direction before by this honorable court, my lord, that both the party appear before us, my lord, will issue.
Yes.
Because here, my lord, what the other party is saying, my lord, it has been done behind the back. Behind the back.
My lord, I don't know whether my friend what he is taking that contrary stand. That order it reflects otherwise. And if he is not.
My lord, may kindly come to page 10, my lord. Sorry, my lord, page 36, Annex 10.
Well, that is seen.
My lord, may kindly see in
the
compliance
court
with
says.
Just a minute, please. In compliance with the order dated so and so, the Honorable Deputy Chief Executive Member, in charge land member are hereby directed to issue joint patta in the name of so and so with respect to patta. These are the pattas, my lord. My lord, if both the parties are not present before us, my lord, how can we issue
Then-
a joint patta and give it to only one person, my lord?
And see the very conduct of the respondent number 8, sorry.
Yes.
See, very conduct.
Yes, yes, my lord. That
smacks of.
Yes, my lord.
That he is playing hide and seek since
That is
2015.
why, my lord, if an order fallen from this honorable court, my lord, that my lord, both the parties
Yes,
appear, my lord,
please
we'll
do
hand
division.
it over, my lord.
That's not the problem, Lordship.
Yes.
Here I am not asking for it. That I just say that you act on your own order. Time and again you are issuing some letter to the mandal that you carry on with the issuance of patta. You are not
If
doing.
your brother is hiding, what can we do, my lord? You tell your brother.
You were served
bring your
also,
brother.
correct?
Pardon?
You were served this matter.
Notice.
Here, my lord, I have talked to Mr. Amit Joshi, my lord. He said, my lord, only
Who's
once.
Amit Joshi?
Amit Joshi, who was appearing for respondent number 8, my lord. So last occasion, I told him that the honorable court want his assistance, my lord, in this matter. He said that, my lord, he was just asked to appear one date, and then, my lord, he lost the communications and all with his client. Only difficulty, my lord, what technical
No, but he
difficulty?
didn't file a title suit also, right?
No, they didn't file title suit, Lordship.
Yes.
Only difficulty is this, my lord. Now, if we issue a patta, my lord, we cannot hand it over to one person, my lord.
Give duplicate copy.
My lord, let both the parties appear, my lord. We are ready to issue, my lord.
He is hiding from me also. There is one. 83. WC 83 of 23. 2019. And this other one getting CRP 6. This is the first petition you filed.
CRP first.
No, not CRP. This is the first one you filed.
Pardon, Lordship?
This is the first one you filed.
Yes, this is my first one.
And he has filed 3.
3, Lordship.
CRP number 6. Yes, tick down. Petition. Again. WC 119 2023. The writ petitioner is before this court by way of the instant application, praying for a writ in nature mandamus to direct the respondents to issue a joint patta in the name of the petitioner and the respondent number 8. Which are mentioned in the orders dated 28/11/2022 and 14/3/2023 issued by the
Revenue
by
officer.
the respondent number 5. Of police. In the nature mandamus. For the plots of land mentioned in the order dated which are annexed as annexures 9 and 10 to the petition. Stop. Next paragraph. The brief facts of the case are that the father of the petitioner and the respondent number 8 was the owner in possession of several plots of land, the details of which have been given in paragraph 2 of the petition. On the demise of the father on 3/6/1998, the petitioner had approached the revenue authorities of the GHADC for grant of mutation of his share of the property left behind by his deceased father. Thereafter, it appears though repeated orders were passed, the said mutation was not effected, since respondent number 8 had raised objections to the same. Stop. Thomas? The objection to the same, and had made submissions before the authorities that he was in possession of a will whereby all the properties had been bequeathed to him. Stop. At this juncture, it is worthwhile to note that the respondent number 8 had 19 had come before this court by way of LPC number 219 of 2019 against the orders of revenue authorities.
One clarification. Prior to that, he filed CRP Lordship. First is CRP Lordship.
It was filed first?
Yes, Lordship.
At a juncture? By way of a civil revision application being CRP number 6/2019 against the orders directing for mutation, which however was subsequently allowed to be withdrawn by this court. White order dated when?
Lordship 15/5/2019. That is page 28 in my
Order
petition.
dated 15/5/2019. Where's the 15/5/2019? No. 15/5/2019.
Well, the order sheet will file in my writ petition, Lordship.
Where is it? With liberty allowed to file afresh. Thereafter, the respondent number 8 again came for this court by way of writ application
219
WPC 219
19
of 2019, and also sought withdrawal of the same, which was allowed by this court by an order dated 18/10/2019. Sorry. They came again which order?
File order dated 24/5/2023, Lordship. The WBC number 83 of 2023.
This is the order which is here now, 14 March 23.
Yes, Lordship, they have.
Like on a subsequent order being issued by the revenue authorities, bracket respondent number 5, on 14 March 2023. The respondent number 8 again preferred a writ application assailing the same, which is numbered as WPC number 83 of 2023. Which, however, was similarly withdrawn and was allowed by this court on by order dated 24/5/2023. Stop. As a prayer had been made by learned counsel while withdrawing the application, that liberty be granted, this court, while allowing the same, had given a rider that filing afresh would be subject to paying of rupees 10,000 cost. Yes. Stop. It appears that the respondent number 8, by the repeated proceedings, by repeated litigation, has sought to frustrate the orders of mutation that have been passed by the revenue authorities. And in fact, in the present proceeding, in spite of service of notice, when was he served?
My lord, that AD card received, that is order dated 3/7/2023.
In spite of service of notice.
And that has been reflected in my lordship's last order, lordship, in this writ petition, who are the counsel had appeared. That is order 21/3/2025, lordship.
And being represented by counsel, on several dates they appear, correct?
Yes, sir.
No affidavit was filed?
No, lordship.
Huh?
No affidavit.
No affidavit was filed nor further appearance made, which compel this court by order dated 7/5/2024 to close the filing of affidavit and proceed ex parte against the respondent being. In this backdrop of facts and circumstances, what needs to be examined presently is only with the prayer of the petitioner to direct the respondents to act in accordance with the order dated 14 March 2023 issued by the respondent number 5. Accordingly, next paragraph, without further discussion, it is ordered that the respondent, the revenue authorities, shall mutate the half share of the writ petitioner along with the respondent number 8 and prepare a joint patta.
My lord,
Yes.
here, if my lord, because that if it is a joint partner, then the entire property should be mutated in the name of both the brothers' lordship.
Yes.
But not the half share lordship.
So you want joint patta half share?
Yes, it should be in the name of both the parties, but
You have not apportioned the share.
Yes,
we,
yes,
we're not,
lordship.
see, we're not going to go there.
Yes, lordship.
Then if you want, you'll have to file a partition suit.
Yes, lordship, yes.
But that the order, which now my friend is trying to read out, which has been in 14 March, my lord. There's nothing mentioned about the division of the
joint patta.
It's a joint patta only, my lord. Without mentioning, my lord, who.
That is why I am saying joint partner.
Okay, fine with it. No. If we don't join that 150, that half share.
Yes, lordship. Joint. That is my.
It's ordered accordingly. Without further discussion. So they mutate the property.
Yes, lordship.
In the names of the petitioner and respondent number 8 and issue joint patta
Yes.
accordingly.
Yes.
Stop. The same shall be completed within. It's a paperwork only. Within a period of 4 weeks.
4 weeks, and my lord, only thing is this, my lord, both the parties may come.
I am ready to.
Both the parties, my lord.
Let him come again to the court. That time we'll catch him.
only things, my lord. What may create a problem, my lord, for this order, my lord, that may bar if in case there is a will, my lord, and he want to provide that. My lord.
See that record of rights.
This order may not have
the record of rights will not protect interest. If he was interested, Mr. D would have come here.
Only, my lord, as an officer of the court,
If gone ex parte,
My lord,
they cannot.
I'll just clarify, lordship. When the first writ petition was withdrawn, lordship, I'll just read out his submission, lordship.
No need, Mr. Sheikh. Law will follow its own course.
My lord, but that will.
Yes. With on the date of presentation of this order before the revenue authorities. The revenue authority shall be at liberty to also issue notice
to both the parties.
Before the date of issuance of patta.
And Hindu law of succession is very clear. Section 8 divorce. Must obey.
That you can make submission before the.
Yes, lordship.
35.
Stands to support.
35.
Please, your lordship. Lordship, the issue herein, my lord, is very limited, my lord. We are aggrieved by the order passed by the chief executive member, my lord. Here, what has transpired, my lord, is that order was passed by the village court, my lord. Thereafter, they were supposed to file an appeal, and after a lapse of 90 days, my lord, they file an application before the chief executive member under Rule 53, my lord, of the
Administration of Justice Rule, District Council, my lord. There, taking cognizance of that matter, my lord, the Chief Executive Member passed an order, my lord. If Lordship is pleased to come at page 39, my lord. This is the order of the Chief Executive Member.
Yes, come again. Why 400 rupees are fighting so much?
In fact, my lord, this is in regard to the protection of the Akang land, my lord. They are actually, what they are doing is that they are planning an arecanut plantation, my lord, whereby it's like spoiling the earth and damaging the earth, my lord. And the rivers, they are actually dependent on the rivers, my lord. By doing that, my lord, they are polluting the river as well, my lord. So they have taken a resolution in the year 2016, where all the villagers have come together and said that they would not cultivate in that portion of land, my lord. But they went against that resolution, my lord. Being aggrieved by that, they informed the respondents not to do the same. But they were adamant, my lord. So they had to file an application before the village court, my lord. The village court thereby passed an order, my lord. There also, they have categorically stated that they will do the same, and they did not challenge the order of the village court, my lord. After that, after 90 days was lapsed, my lord, they file an application before the Chief Executive Member, my lord. The Chief Executive Member passed an order forwarding the matter as a decree, my lord. Sorry?
It's an Akang dispute.
No, this is not no, it's not a dispute with the Akang, my lord.
Yes.
So after that, my lord, the Chief Executive Member forwarded the matter to the additional judge, District Council Court, my lord.
Order? Sorry. Let's see.
This is the order passed by the Chief Executive Member, 39, my lord. If Lordship may please to see para 3, my lord, as per Rule 53.
So, machine.
If I may be permitted to read, my lord.
Yes, please.
As per Rule 53, Sub Rule 2, whenever an application is made under Clause B of Sub Rule 1 of the aforesaid rule, the application is to be considered as a decree only which need to be executed keeping in mind the spirit of CPC. This being the position of the case, I have tried to execute a decree by summoning the accused persons, respondents, but they did not cooperate and failed to appear in my court. Since all options have been exhausted, hence left me with no other option but to move this case to the Court of District Judge, Additional District Court, District Council Court, GHDC, to take necessary legal action, including issue of arrest, warrant and detention in the civil prison for realization of the aforesaid fine amount in view of Sub-Rule 3 of Rule 53 of the Garo Hills Autonomous District Administration of Justice Rules 1953. After this, my lord, this matter was forwarded to the additional judge, who thereby endorsed the matter to the assistant judge, my lord. The matter proceeded thereafter, my lord. Several days went by, my lord. Then, all of a sudden, out of the blue, my lord, the impugn orders, page 43, an application was filed by the private respondents, my lord, and he...
What is handwriting?
Yes, my lord. 18/3/2024, my lord.
Yes.
This is the impugn order, my lord. We are challenging. Since the petition submitted by Sri Dilipson Sangma,
That's
judgment...
what exactly now I remember this case.
Lordship.
Why you aggrieve? You filed for execution for realizing
Yes, my
100
lord.
rupees. That means they will have to admit that they were illegally cultivating.
Yes, yes, my lord.
That's all. And so why let them? Why do you not allow them to appear? Let them appear and then let them execute.
No, that is what, my lord. This, after the matter was taken cognizance by the assistant judge, my lord. Chief Executive Member, out of the blue, my lord.
Yes, Mr. D.
My lord. Yeah, my lord, now what has happened, my lord? The entire scenario has changed, my lord. An appeal has been filed. Appeal has been admitted.
With appeal? Against village court order?
Against village court order. And my learned friend is also aware. Now, what will be the position of this order, my lord, when it is admitted and probably...
There has to be this...
Have you
order
challenged the second proceeding? Order of village court was passed when?
It was passed...
In?
4/8/2021, my lord.
It is 30 days, right?
Lordship.
Appeal period?
90 days, my lord.
90 days, sorry.
Lordship.
Beyond 90 days they file.
Yeah, beyond 90 days they file, my lord.
Where's that? You brought that on record?
No, my lord.
They have not brought it.
Affidavit filed by respondent number
Let's see. Oh, yeah, there in the corner. Yes. Affidavit number by
3 to 16. Lordship.
91. Wow. So the decree against you is 21. Why didn't you pay 500 rupees?
Only 3 submissions, Lordship. If Lordship is pleased
Yes.
to come to page 6 of my affidavit.
One second. Page. One second.
Page 6.
One second. This is affidavit filed by
Respondent
3 to 16. Okay.
Page 6, para A, B and C.
Page 6, para 8.
B and C.
Yeah.
Essentially, Lordship, there is a requirement under the rules that the village court will consist of 3 members.
You challenge the jurisdiction to village court now.
That is one part.
After how long?
No, this I have challenged in the instant.
No, after how long? After the village court order?
Lordship, I have filed my appeal along with the continuation
When?
of delay application in the year 2024. That has been admitted. Rightly, wrongly, it has been admitted.
No, but I'm not aggrieved by that order, my lord. I'm only aggrieved by the order of the chief executive member, my lord. As of now.
If that is the case. See, one thing, Mr. Moment.
Lordship.
Now the thing is that you are seeking to execute your
Yes, my lord.
500 rupee decree. Right?
Lordship.
Now, in the meanwhile, they have preferred an appeal.
Appeal.
against
Yes,
that
my
order
lord.
also. So now, what will be the fate of your execution case? Well, what if proceedings on execution case? That's all. You feel that by implementing the decree,
Lordship.
them paying 500 rupees, that means that is a recognition of your, your right over.
Yes, my
right?
lord.
That's all. Right?
Yes, my lord.
Then it can't go on like this, because if the appeal is there, there's a substantial appeal versus execution. So
No, that is what I'm saying, my lord.
Only thing is this, my learned friend, what I could have understood from his submission.
then
is
you set aside an order.
Yes, my lord. We just want that, my lord.
Before the
My
judge.
lord, here, my lord. My lord, may kindly come to my affidavit, para 9, my lord. Page 4, my lord. Para 9, my lord. That in reply to the statement made in para 11 of the writ petition, the answer and respondent might have got it.
Yes.
The answer and respondent back to submit that under Rule 53 of the 80 rules, the CEM shall get the order executed according to the spirit of CPC, and as such, the application for recalling of an ex parte order shall also lie before the CEM, my lord.
There is no come there. No, it has not come there. You see, what is agreed with after it's endorsed to the additional judge without other further orders, the CM has taken it up.
Yes,
if
ma'am.
in case the order was an ex parte order, my lord, whether they was heard before the CEM, my lord.
Now the question would be, my lord, how can he recall his own order once the matter has all been forwarded to the assistant judge, my lord? And the matter...
In case, my lord, set aside this...
No,
order
they're
also.
still proceeding the matter before the...
In case, whether there will be any gain for my learned friend. Because, my lord...
So what gain will he get with by remaining that order, my
See,
lord?
one thing, Mr. Day, he had passed an order on 19/9/23, correct?
Lordship.
So expedite matter complete the whole process. Now, what has happened is that there's an independent appeal that's going on its own way.
Yes.
Now, the only thing he's agreed with is this order.
Order, yes, my lord.
We'll take down, yes.
Only one aspect, Lordship.
Yes.
One of the grounds of appeal was that the village court, under the rules, could not have imposed a fine of 500 because
We're not going to, that's your appeal. You can
There is an appeal is pending, my lord.
Anyway.
execution may be subject of the appeal. Subject of
We're not directing for execution.
No, the execution cannot even...
We can't direct for execution here.
Yes, my lord. We are only agreed by this order of the CM, my lord.
Yes, yes, the petitioners. The petitioner number 1, who is stated to be the Nokma of para 3, Sokadam stroke Sodamgre, I think, along with other petitioners, are before this court, being aggrieved with an order dated 18/3/2024, passed by the respondent number 2 chief executive member, whereby though by an earlier order dated 19/9/2023, the matter, an execution case being execution case 19/2022 has been referred to the court of the district judge stroke additional district court, district council court GGDC, without any effective orders, and when the matter was already seized by the district council court, respondent number 2 had passed orders for restoration and for setting aside the orders inflicting the fine. Set aside the order of the village court.
No, the set aside its own order, my lord, 19/9.
Set aside order dated
19/9/2023.
19/9/2023 without any reasons being ascribed. So, next paragraph. Mr. E.G. Moen has submitted that the short issue in question, he has submitted that the petitioner's limited grievance is with regard to the legality of the impugn order, whereby on an execution case being filed by the petitioners, the same had been referred to the district council court. The respondent number 2 had again taken up the matter without any cogent reasons being ascribed. It is further submitted that the petitioners are aware about other parallel proceedings with regard to the appeal from the order or decree for which execution has been sought. He always submits that being independent proceeding, the passing of the impugn order has clouded the proceedings. So he therefore prays that impugn order be set aside and quashed. Stop. Next one, Ms. SD appearing for the official respondents 1 and 2 has submitted that the execution proceeding had emanated from an order of the village court of Samanda.
Yes, ma'am. Yes.
Village court, whereby a fine of ₹500 had been imposed upon the prior respondents 3 to 16. Stop. This order is submitted, though belatedly, has been appealed against, and the matters is seized with the assistant judge, district council court. Stop. With regard to the impugned order, the learned counsel has submitted that DCEM is well within its powers to recall its own orders and to pass necessary orders thereon. He therefore submits that no interference is called for, and as the appeal is pending consideration, the parties be left to contest the proceedings, to contest the case here. Please stop. Type for Mr. SD appearing for response 3 to 16. What's your submission?
Similar lines also, appeal is pending. So
Has concurred to submissions made by the Ms. SD and submitted as the appeal is already pending. There's no question of, and the same having been admitted
pending before the
pending for assistant judge. There's no question of the execution case being taken forward. So next paragraph. I've heard the counsels for the parties. Stop. And also perused. Stop. I've also perused the materials from the court. So it is correct that the Samanda Village Court, by order dated, you kindly assess the code. Order dated
4821, man.
4/8/2021 had passed and had ordered 21. Where's the order?
Page 31, my lord. Just the type copy.
Of the petition. Had ordered page 21.
31, my lord.
And ordered all of them are here.
500 each.
The respondents 3 to 16 to where's the 500 each? Oh yes.
At page 33, my lord.
Had to pay a fine rupees 500 per head to the petitioner, as they were found to have planted and cultivated acornut on land stated to be reserve forest of the. You said your reserve forest, right?
Yes, sir.
So reserve forest of the petition number 1. Stop. In pursuance to this order, the petitioner therefore has sought execution of the same to compel the respondent 316 to pay the fine as imposed by the village code. Stop. The respondent number 2, on the matter being placed before him, had then directed by an order dated 19/9/2023 by quoting Rule 53, Sub-Rule 3 of the Garo Hills Autonomous District (Administration of Justice Rules 953) that the matter be placed before the assistant judge. Where's the
additional judge?
Before the court of the additional
judge.
Court. Yes. And accordingly, it appears the matter had then proceeded before
assistant judge.
This is the assistant judge.
Yes, my lord.
District Council Court. The order dated 18/3/2024. Therefore, on examination, appears to be misplaced, as much as no reasons are ascribed. And the matter has been, what do you call it? The matter has been taken up by the respondent number 2. this order in the consent with the court being unreasoned and all reasons does not stand scrutiny of law and is accordingly set aside, leaving the parties to contest the execution matter before the court of the Assistant Judge, the Council Court. Stop. As it's also reported that the appeal against the court of the village, against the order of the village court, also pending for the same court. Stop. This application is closed, therefore leaving the parties to agitate the grievances before the court of Assistant Judge, the Council Court Tura.
Highly obliged.
All above matters stands closed.
Highly obliged.
And this person. Yes.
This case was there, my lord. Can be closed.
This case is yes. Hearing us. Huh? Not hearing you. Any other hearing?
36?
This court won't sit beyond 1:30.
36, I am praying for 2 weeks.
36?
I've informed the other party also, the petitioner.
No objection, sir.
Yes, 2 weeks or 3 weeks?
Let it be 3 weeks.
Or 4 weeks?
No, a lot. Not
2 weeks,
Your
Lordship.
For 2 weeks on the prayer of the GAS. Right?
Obliged.
38?
Your Lordship, in this case, this matter is with regards to non-payment of gratuity, Your Lordship. And the petitioner, he's yet to receive his gratuity, Your Lordship, since he...
Last time we heard you, think?
Yes, Lordship, at length.
Yes.
And they were supposed to come up with instruction. Your
Where's
Lordship,
Mr.
AG.
Where's Mr. Kikama Plang? This is against this is on Monday or Tuesday. Then this is on Tuesday.
Yes, Lordship.
Yes, due to absence of Mr. Kikama Plang, the counsel for open general this matter on Tuesday.
Supplementary 1, item number 1.
May please, my lords.
What is this?
My lords, this is again one of those matters, my lords, where there was a contract of supply of ferrosilicon to, my lords, Sale India Limited. Now, what had happened is, my lords, in the plant of the petitioner.
Yeah, the best
Just keep that P1 ready.
Where's the impugn communication?
Well, it's. My lords would find it at page. Annexion 9, page 181. At 182, if my lords kindly have the last paragraph.
Yes.
In the aforesaid backdrop, you are requested to supply the pending quantity of ferrosilicon at all the sale units within 15 days from the date of this letter without any further delay, failing which sale will be constrained to initiate action as per the terms of the contract and procedure, the balance quantity from alternative agency at your risk and cost. So basically they are threatening, my lords, a risk purchase.
This email?
This was got by us on 19, I'm sorry.
No, did you write to them again? Where is that?
28th March 2025, my lords, we've got
Did
it.
you communicate with them after this?
Post that, no, my lords. Because they have initiated, they say, my lords, within 15 days, either you do it or we'll initiate risk purchase. That's the sum and substance of the matter. Now, a similar issue, if your lordships would recollect, my lords, had come before your lordships a couple of years earlier.
Yes.
Well, then that matter was disposed of by this honorable court by judgment on order dated 5/4/2022. Well, that was Pioneer Carbide versus Union of India. That matter was again carried in appeal before the division bench, my lords. And in the division bench, some orders were passed, which, my lords, actually put quietus to this entire matter.
Yes, Ms. Young.
Your Lordship, will take notice on behalf of Respondent number 1, Your Lordship. And Your Lordship, with regards to the interim prayer, let it be considered next week, Your Lordship.
15 days.
What I'm simply saying is, my lords may issue notice at this stage because sale would have to be represented before this honorable court. And my lords, let status quo as on today be maintained, whatever is the position. This matter was basically, my lords, what we had argued even at that stage was that once there is an arbitration clause, that these matters would be covered by arbitration. Because force majeure
What
here.
is held to be non-maintainable? What is this you're showing?
Which doesn't have to
No, give the DB order.
What order are you showing?
Well, it's that.
Give me a copy of the DB order.
I'm sorry, I think, my lords, this is the judgment passed by this honorable court, my lords, which was carried in appeal.
Yes.
My friends have given the single judge's order. This, my lords, thereafter, my lords, the division bench held, my lords, that this was an arbitrable dispute. So essentially, the matter had to be carried in arbitration.
Right.
And thereafter, my lords, the matter was finally carried in arbitration and the matter was settled between the parties.
Same parties?
No, this is, my lords, with another company.
Yes,
Respondents were the same.
The policy counsel assisted by sponsor. Petitioner issue notice. Ms. Merichiang Vice Dr. M. Wazika. Exempt house number 1. Notice to issue to other respondents within 3 days term. The grievance as put up by the petitioner is with regard to an impugned communication dated 28/3/2025, whereby the respondent's number.
Well, this is issued by the respondent number, deputy manager. Well, he'll be respondent number 13. Well,
13.
I'm sorry, 13 is Bokaro. Road killers. It will be respondent number 3.
Issue number 3, whereby action has been contemplated against the petitioner of invocation of where's that 20 from yes contemplated against the petitioner for failure of supply or balance quantity of ferrosilicon. Which the petitioner has attributed to the explosion caused in the furnace stop. Is submitted by Mr. Gaypal that in view of the accident that has happened in the factory, the force majeure clause has been invoked, which however has not been acknowledged by the respondent number 3. So at this stage only prays that status quo be ordered, so that what the risk purchase is called?
It's called risk purchase, my lords.
Yes. So the risk purchase clause not inflicted upon the company. On hearing the senior counsel, however, as the respondent not represented, it is provided for the ends of justice that the next date no course of action be taken against the writ petitioner.
After 2 weeks, my lords. In the meantime, we'll take steps.
Madam.
Highly obliged.